You know, I have to scroll through these. No, hold on. On this one here, I've got a order to show cause, it's signed by Judge Terrell, and he has to move the case up to September 22nd, and it's signed. So I just have to show cause, that's it.
Yes, and the attorney record is Marcy Jacob. She contacted me. She had a medical issue that last night and today, so she asked me to postpone the case.
Still,
First off, are we on the record? I want to go on the record. I want to state my name, my address.
Before I go on the record, I want to hear what you're going to say. I'm going to get a record of the conference, and this is your motion. In any event, whatever happens, it's something from me, guaranteed. You're going to get something in writing if I am taking a motion in and hearing it. I'm not going to leave anything alone.
So
I see at the moment, Judge DeBerry signed the show cause, move up the trial date. I have no opposition.
I can't really hear you, but
I have no opposition.
you want me to speak off the record, you're saying?
I want you to tell me about your motion.
My motion?
Yeah, you have this one, you've got a motion to have the case scheduled for September 22nd. Sure, why not?
Yeah, so you want me to speak on that motion off the record? Because I don't like speaking off the record. I like to speak on the record.
If this is something that, if this is a trial, you're on the record. If this is a conference before I find out what to do with this motion, you're gonna get a decision on a motion one way or the other. I see there is no opposition to your motion to have an expedited trial date of September 22nd. And this gentleman is coming in today telling me there was an attorney who was sick. Do you want your trial on the 22nd?
This is my point. I want this to be on a record because we talking about a lot of things and it's not on the record. And this motion, Your Honor, this motion that you're referring to, this is a separate court date. This has nothing to do with the motion that was filed. This court date was already scheduled. This is why I like to speak on the record, because none of this is being on the record. The motion you're referring to has nothing to do with today's court date.
I'm not deciding the motion off the bench.
Yeah. This guy's crazy, man.
So I submit the motion, get a decision.
Your Honor, this court date was scheduled before the motion was filed. This court date has nothing to do with the motion.
You want September 22nd? I'm saying fine.
I'm telling you, this court date was scheduled before the motion that you're referring to. So how does one thing have to do with the other? The motion doesn't have anything to do with today's court date.
The motion's asking for September 22nd. This is going to be on September 22nd. I'm saying, yeah, you want an order putting it on for September 22nd?
How can you entertain a motion that has nothing to do with today's court date? This court date was.
You're asking for it. This is your motion. You're asking for it.
This court date was already scheduled before I filed that motion.
Yeah, and the motion is requesting September 22nd. So you want this on September 22nd.
I'm appearing here for today's scheduled court date. That's what I'm here for. The motion, I said it 3 times. The motion you're referring to was filed after this court date was scheduled.
Okay, so
it has nothing to.
Right. So you scheduled for. I get it. So you got scheduled for a conference today. Okay. So we can do a conference, and then you want the motion also. We can do the conference. I have no problem with that.
The court that you're referring to, that was already granted by another judge.
Yes.
So how are you entertaining something that was granted by another judge? that was already granted for September.
Yeah, so you're there, you're on for September 22nd.
Right, so can we still,
And
are you
that's
still
what-
gonna preside over the case today?
Well, I mean, do you wanna do it today and the 22nd, or do you want?
Yeah, I'd rather I would do both, or depending on what's gonna happen today. We could,
One or the other. I mean, in terms
Right.
of that, you know, you're asking.
well, it depends because I've been treated unfairly coming here, wasting my time. So if you're gonna be fair and impartial, then there's no need to come back. If you're
So
gonna
what do you
take
want
care
to
of
do?
what's like
Tell me about this case.
off the record.
Yeah, we're trying
Why would I
to-
talk? Why would I talk about my case off the record?
If you want a trial, then you won't put it on the record, but then I need to schedule it for a trial.
Why? All of this I've been saying so far should have been on the record. Everything needs to be on the record with me. All right. So if I'm gonna tell you about this case,
This is my courtroom, and I'll go on the record when at this time, I'll go on the record if I'm on trial, or if I'm entertaining, oral argument, I'm gonna do a decision on the record, so you can get a written record. If you wanna go appeal, I have no problem with people appealing, I have no problem with people re-arguing, and I have absolutely, it's my pleasure to give you a written record of that. But if I'm talking about conferencing the case, we're just working on dates, I don't need to go on record. So
can I just
tell me
look?
what you wanna do with this case, you know?
All right. This is for what? Bronx Honda?
This one is Bronx.
Because the last time I checked, he's representing Plaza Honda. Now
Yeah,
today he's representing Bronx Honda. I don't.
He's not. He's not.
So who's representing Bronx Honda?
I have here listed
So why is he
Marcy Jacob.
Why is he sitting here if he's not representing Bronx Honda?
He says he's here today on behalf of Marcy Jacob.
So he's representing Bronx Honda then.
So no, you're here as a counsel. If you make that clear.
Yeah, I'm of counsel on Marcy Jacob.
And none of this is on the record?
Right.
What type of proceeding is this? None of this is on the record. I don't like.
Since when do you control the code and say what's on the record?
I'm not trying to control.
Yes, absolutely.
I need to know what's going on. I thought he was the defendant.
What's going on?
He's representing
What's
Plaza
going on?
Honda.
What's
Now
going
he's
on
representing Bronx Honda.
Is that you've made a motion that's returnable for September 22nd.
Oh, you gotta play games with me, man.
Okay, that you need to serve on for today. The motion's returnable for the 22nd, you're asking for expedited trial date. And I'm telling you, I'm absolutely fine with that. So this one, Bronx Honda, I'm arguing for September 22nd.
Hold on.
No. I'm moving on to the next case. Terrell Taylor versus Plaza Honda, number 11.
Your Honor.
Wait. How are you gonna do?
Okay,
You're not gonna let me speak on the case?
You have an order for September 22nd by another judge. I'm not stepping on the code. All right, so that's it. Let's go to number 11.
You're wrong. I have to address something. I have to address the court, please.
No. Go to number 11. This is Plaza Honda. Now, what's your name?
Sean Smith.
Okay, so you're the attorney for Plaza Honda.
Correct, Your Honor.
Okay.
Wow. This is crazy.
And I filed a motion to dismiss in this case, which is known as random motion count.
Let me bring it up. Part 11. Alright, so, in this case, alright, I see there's been quite a history, so, the complaint, pardon me for a second. Okay, fraud, discrimination, $50,000, interest from January 14, 2025, filed January 23rd, 25, and the answer filed March 19th, 25. There was a motion to waive court fees on March 24th, 25, denied by Judge Doshi. Then went to April 8th, which was adjourned over. April 20th, there was a defendant's motion to vacate the inquest clerk marking. That was granted by another judge, Goldman. Then it came on for July 29, 25, it was adjourned for trial to 9/3. In the interim, there's been an order to show cause to schedule, that was submitted to schedule inquest, which was denied by a judge today. And after that, now I've got a trial, a motion to dismiss, but Mr. Taylor has to have an opportunity to respond to this.
Understood.
So, you know, that's a problem. What would you like to do with this?
You're not gonna let me go on record? If not, it's cool. I'm just asking. You're not gonna let me go on record with this case either?
I'm the one asking the questions, okay? When you wanna switch, very good, go to law school, you come up here and you can ask questions. What do you wanna do with this case?
I wanna speak, but I don't wanna
I'm
speak
giving you an opportunity to speak.
off the record. Okay.
I'll go.
I speak off the record. You're forcing me to speak off the record.
No, I didn't force anything. I'm asking you what you wanna do with this case.
First off, Your Honor, this is different from what I'm familiar with. I usually state my name, my address, I raise my hand. I'm not doing any of that on the record. This is weird to
You
me.
might get there. Hopefully one day we get there with the trial.
I want to get there. I want to tell you about the case, just in case I have to file a complaint and the record has to be looked into.
Right.
I want the record to reflect what took place or what I'm saying. But you're not letting me speak on the record. You're not letting me speak on the record with my last case or this case. So I'm not trying to hold the court up. I want to speak.
So, I'm not going to get into that, but there's no court rule or law that everything that transpires in the courtroom is on the record. You know that, right? You know that.
Even legal
You know
issues?
that. You know that.
Legal issues?
You know it. You know it.
All right.
Okay,
So let's
go on.
okay, I'm gonna speak.
I hope to get on the record with a trial or some sort of decision because this is going on for a while.
Okay.
This was filed in January.
Okay. So on April 8th, right? There was an inquest hearing.
Yes.
The Judge Ernest J. Cavallo stated that since the defendant showed up, that he can't move forward with the inquest hearing. And as a result of that, the case got shot. He sent the case to this courtroom right here, room 101.
Yeah, I saw that.
It should have never left the inquest part, because when it comes to an inquest, the defendant, it's a one-sided trial. The defendant is not even supposed to appear, and if they was to appear, they have to have a valid reason why they didn't answer. They had their time to answer, they didn't answer. This is why the inquest hearing was held.
Yeah.
So there's no need for the defendant to show up. So I'm still speaking on this to this day. This was April 8th.
Yeah.
It should have never left the inquest part. I shouldn't be in this room right here, 101 conference. My case should be in the inquest part. Nobody can tell me why did it leave the inquest part, or what I was told.
Well, this is I'm reading here. This is what I'm reading from this. If you have a copy of this, it says plaintiff wanted the court to pursue the inquest. This is from April 8th. Even though the defendant was answered late and put in a notice of appearance, plaintiff has the right to reject the late answer, which he did orally. Okay. Defendant will make a motion to file late answer. Inquest is adjourned until May 20th, 10 a.m. If the defendant fails to vacate default, default successful, then it's adjourned to July 9th. So, all right, so I'm following you with what happened with the inquest clerk, and then I see there's a decision here.
So
Then what happened?
So the decision that you're reading on April 8th is totally different from what I was told in the courtroom. Because I just stated to you what Ernest J. Cavallo told me. And what you're reading is something totally different. So,
okay. I can understand your frustration.
No. But either way you flip it, if you go off of this decision, or if you go off of what...
Oh, you've got a copy of it, yeah, okay.
I have a copy of everything.
Right,
If
so
you go off of... Can I speak, please?
Yeah.
Can I speak? if you go in, if this decision is gonna, neither this decision or what I was told in court justifies the case leaving the inquest part. However, you can't get around it. Why did the case leave the inquest part? There's no legitimate reason why the case, got shot down to this courtroom. There's no, even if you go for this decision, they had their time to answer. The 20 days exceeded. That's why the inquest was scheduled. Then when I got there, like I said, Judge Cavallo said that being that the defendant has appeared, he can't move forward. So right then and there, that's wrong. The defendant is not even supposed to show up. It defeats the purpose. They had their time to answer. They can't show up at the inquest. They had their time to answer. That's why the inquest was held. So that's what I was told, verbally.
Who told you that?
Judge Ernest Cavallo. And then his decision is something totally different. But this decision still doesn't justify.
He told you couldn't do the inquest because the defendant showed up there.
Exactly, and the defendant doesn't. The inquest is a one-sided trial. The defendant is not supposed to show up. So for Judge Cavallo to say that makes no sense. And that was his reason for sending this case back down to this part. But then when I got the decision, I asked for a decision that same day. He didn't give me the decision. He said he's gonna mail it to me. It's dated the same day, but he didn't give me that decision in the courtroom. So he mailed the decision, and now it says something totally different. But this decision still doesn't justify.
So what did you do with the decision then after that?
Huh?
What did you do then?
With this decision?
After that, yeah. After you got it.
What did I do with it?
Yeah, So, it's another sequence of events.
Your Honor, if I may, I made a motion. Oh, I'm sorry.
There's another sequence of events? And what do you see?
That's what I'm asking. So what happened afterwards?
Well,
you got the decision. And then what happened?
I filed the complaint. I mean, are you even taking in consideration what I told you?
Yeah.
It seems like you just skipped over what I just told you.
I've got a number of other decisions going on from different judges. So as part of what...
Right, but I know what you're talking. I have that decision too. I have it too.
Yeah.
You're talking about the decision from Michael H. Goldman. I have all of that. This is irrelevant though. This is irrelevant because this comes from this decision is from what Judge Cavallo decided to do, which he couldn't do.
When is it?
So
The Goldman decision. That's...
May 19th.
All right.
this is what we need to start from. This decision right here from the inquest. You have it. This is decision after inquest.
And then the second one.
It should have never left the inquest part.
Why?
Period. I just told you why. Because if we going off of this
So
decision,
if the defendant shows up at the inquest, they're not allowed to proceed.
but the defendant,
Yes or no? Yes or no?
huh? And ask me
Yes
that.
or no? Are they allowed to proceed? If the defendant shows up, can the inquest court proceed? Do you know? What law are you citing to that?
What law did I
Yeah,
cite?
what law are you citing?
The judge didn't even cite a law.
What law are you citing to that?
What?
No, you're not.
You can't. The defendant can't show up to an inquest. An inquest is a one-sided trial with me just being there. So that doesn't apply.
Where did you learn that?
Where did I learn that?
Yeah.
It's in the rules of the court.
So my question was, if the defendant showed up at the inquest, that you maintain that Judge Cavallo was authorized and has actually mandated to proceed with the inquest.
What I'm saying is that the defendant is not even supposed to show up, period. So that whole, when we talking about a defendant showing up, it doesn't even apply. It's irrelevant because it's a one-sided trial. So why are we still talking about the defendant? I'm the only one supposed to be at the inquest hearing showing my evidence. That's it.
Okay, so...
They had their time to answer. So if you don't answer and the inquest is being scheduled, how are you going to come and answer now? That doesn't make any sense. But once again, an inquest hearing is a one-sided trial. I'm the only one that's supposed to be there. The defendant showing up is irrelevant. So this should get scheduled sent back to the inquest part so I can have an inquest
You
hearing.
submitted a show cause to Judge DeBerry, to resubmit it to the inquest clerk, and that was denied. That was denied
Right.
on August 11th.
Right?
Based upon the order of Judge Goldman, okay, vacated the inquest clerk marking, and the defendant's default was relieved, and they filed an answer. So that's where I am here today. And now the defendant has filed a motion to dismiss. And what do you want to do with that?
Once again, this case should be in the inquest part.
I can't go back and rewrite these other judges' decisions. That's the law of the case. I'm not stepping
What
on
judge
toes.
this-
I'm not overruling. I'm not the appeal court to overrule those judges. Those judges have made their decisions. That's what I'm dealing with. I'm dealing with all
And
this.
when you say judges making a decision, you're referring to Michael Goldman and Ernest Cavallo?
Again, once again, I'm asking the questions.
No, I'm trying to get clarity. When you say judges, you don't want to step on judges. You're talking about Michael Goldman and Ernest J. Cavallo, right?
I'm not answering your questions because
I
you
don't-
want relief from the court. You're here, and I'm asking you, what do you want from me?
My
Then
rights were
you want
violated.
to go on a-
My rights were violated. You're not going to do anything about that? You're going to just
What rights-
sweep that under the
What
rug?
rights been violated?
Due process. 14th Amendment. My
What
inquest
case
hearing?
are you citing to under the 14th Amendment that says that's wrong? What case?
A case?
Yes, you have a case?
The rules of the court state.
What court rules say that's wrong?
Huh?
What court rule specifically says that that's incorrect?
That what's incorrect?
Okay, no, you don't have an answer to that.
No,
I'm gonna fast forward to today, and there's a motion to dismiss. What do you want to do?
I've never received a motion to dismiss. It wasn't served on me, so I don't even know. How can I, oppose a motion that wasn't served on me? I don't even have a motion to dismiss. What was this? Handed up today?
Do you have proof of service?
I do have an affidavit of service. I filed that with the court.
Well, I don't see it.
It's filed by BBBS.
I don't see it.
I can give you a copy, Ron. I served him on August 15th, 2025 at 174-22, 125th Avenue, Apartment 2, Jamaica, New York, 11434.
All right. So, looking at your motion to dismiss, and I will do this on the record, as a matter of fact.
So, wow, this court is crazy, bro.
That's enough. Stop.
Look at what
Stop
he's
mumbling. Stop it.
All right, so this is on the record. Okay, this is a recall of calendar, part 11, calendar number 11, Terrell Taylor versus Plaza Honda. Also, calendar number 30, part 35, calendar number 3, Terrell Taylor versus Plaza Honda, index number CD-001-848-25, /3, appearance by plaintiff and by defendant. Officer, swear you in.
So I'm going to ask you to please stand up and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please have a seat. I'm just going to ask you to state your name and address for the record.
Terrell Taylor, 174-22, 125th Avenue, Jamaica, New York, 11434.
Down.
Sean Smith, 946 Ridge Boulevard, Brooklyn, New York, 12209, for the defendant, Plaza Honda.
Okay, before the court today is a notice of motion to dismiss plaintiff's action pursuant to 3211 and paren 2, and for such other relief. I do not have an affidavit of service. Plaintiff, I'll hear your argument, and then, defendant, I'll hear your argument, and plaintiff, I'll hear your argument. Go ahead.
Yeah, I have the affidavit of service, Your Honor, affirmation of service. Basically, the plaintiff sued for fraud and discrimination. My understanding is that he came into Plaza Honda in January of 2025 with the idea of purchasing a vehicle. There was no Plaza Honda made some efforts to obtain financing for the vehicle that the plaintiff wished to purchase. However, the plaintiff, from what I'm gathering from my affidavit from my client, was unhappy with the credit terms provided by various lending institutions. So no transaction took place. There was no monies that went back and forth between the plaintiff and Plaza Honda or any affiliated entities. No monies changed hands whatsoever. He was simply unhappy with the financing terms, and he subsequently filed a lawsuit. I sent discovery demands to the plaintiff. I never received a response, and you know, there's no transaction for which there's a cause of action might arise.
Mr. Taylor?
I know what took place. It's not necessary for me to speak on that. I'm still speaking on what's going on in the courtroom. That's what I'm speaking on.
I'm speaking about the motion.
You're speaking of what motion? You just said, all right, if
Well,
it wasn't.
Well, if you can follow up on that, what's motion? So if you
Right, I never received a motion. You just said it was no affidavit of service filed or affirmation of service. So why would we speak on a motion that was never served on me? Could we just, like, I can't speak on a motion inside the courtroom today. It would have had to been served on me, and I filed an opposition. It wasn't served, it wasn't filed with the court, so I don't see why we talking about that. We talking about that instead of my due process being violated with this inquest hearing. When they didn't respond to my summons and complaint, we not even speaking about that, but we speaking about a motion that wasn't even filed with the court or served on me. That's what we're gonna speak on?
Okay.
How are we gonna speak on that?
All right, so before the court there is a notice of motion. It is devoid of an affidavit of service. It is also devoid of an affidavit of anybody with knowledge of the facts or of the claim.
There is an affidavit.
I don't have anything before me at the moment, so that motion is denied. And I'll memorialize that in writing. I have a notice of motion, a bare notice of motion with nothing more, okay?
Well, it was filed by EDDS.
Well, maybe you filed it wrong, file it again. Meanwhile, I have a trial today in this action. So if you wish to go to trial now. We're not. I'm giving you an opportunity if you're ready.
To go to trial now?
Yeah. Or you want to put it on the 22nd with the other one?
I'm away on the 22nd, Your Honor.
Your Honor, my rights are being violated in this
You can have a
case.
trial right
So,
I'm asking you, would you like to have a trial today or another day? Because it's scheduled for bench trial. His motion to dismiss is denied. What do you want to do?
I'm gonna put in for a jury demand because I don't do bench trials because my rights, I have a history. I have a bad experience. I have a bad experience with judges violating my rights. I'm telling you that's happening in the past and you're doing nothing about it. There's no way that I'm gonna do a bench trial when I'm telling you judges are violating my rights and you're doing nothing about it.
Right,
that's why I would rather do a jury trial. But can we go back to
All right, that's enough, let him talk.
All right, so let me speak with you. Yes, so that's fine. I'll give you another date. I'm not aware, I'm sorry, because I think it's the first time I made it. I'm not aware of past and everything that happened, and I do appreciate and understand if that's happened, first time I'm hearing it, I'm cognizant of it, I'm empathetic to that. If it's something that you want to do and you're right, jury demand, or you're right, proceed elsewhere, that's fine. But I can put this over, this motion is dismissed, and then this will be, I'll give you a new date in the interim, you can file whatever you want to file.
all right, before you do that, can I say something?
Yeah, sure.
I suffer from a work-related injury. Y'all been wasting my time. You said you're willing.
What date is good for you?
You said you're willing to hear me out, and you know, if rights were violated, this your first time, you wasn't made aware of it. I'm making you aware of it right now.
What's before me today?
I'm making you aware of it.
I'm hearing you, yeah. And what's
So
before me,
if we
this case says bench trial with the motion to dismiss. Motion to dismiss is gone. So now I'm left with bench trial, and I'm ready to go.
Well, I'm
If you
trying.
wanna go now, let's go. If you have an injury and you're trying to do other things, that's fine.
You're not listening to me though.
Okay, go ahead.
What I'm saying is,
I'm listening, Mr.
what I'm
Go
saying is
ahead.
this.
I'm listening.
Once again, I suffer from a work-related injury. Enough of my time has been wasted in this coming back to this court. So when you say you're gonna adjourn it and do all of this,
I said I'll give you a trial today if you wish.
right. But I told you why.
You can do it the next day.
I explained to you why I don't want to do that.
Okay.
Because judges has been. I have to keep saying the same.
Okay.
Judges have been violating my rights here, and I'm making you aware of it. And you're doing nothing about it. So I would never want to bench.
I can't undo what these other judges have done. That's history. I can't change what they do.
All right.
I can
So
only talk from
all right.
today going forward.
So
I can only do what I
got you. So I'm gonna make this brief. Then I'm not gonna hold you because. So let me just get this straight. So because I'm focused on the inquest hearing because they didn't answer. I heard what you said. You're not gonna help me with that. I'm not gonna keep beating the dead horse. That's what I want to focus on. So now we're gonna make an adjournment, and then I'm gonna have to put in for a jury trial. If that's what I have to do, cool. That's a waste of my time. I've been sitting here wasting my time with this court keep coming down here. It's frustrating. I'm tired of it. They didn't answer. I put in for an inquest. It was scheduled. The judge did me wrong, violated my rights. You're not gonna do nothing about it. Cool. I'm forced to put in for a jury trial, a jury demand, and come back here and do this all over again. If that's what you're gonna do, then let's do that then. But I'm telling you, you should schedule this for an inquest hearing because.
Like I'm saying, I cannot go back in time.
All right,
and
cool.
do
No problem.
what was done.
Nope.
I have in front of me a bench trial.
Nope.
If you don't want the bench trial, I'm okay with that.
Yeah, I definitely don't. Not if look at what's happening. You think I would want a bench trial? I don't want no bench trial. So
I understand.
we can make a short adjournment because this is a waste of my time. And throughout that adjournment, I'm gonna put in for a jury demand so I can have a jury trial. That's my only option here because this is very unfair to me. Very unfair.
Do you want it with the second one and the 22nd because you have to come back multiple times?
I'm gonna be out of the country, Your Honor, on the 22nd. Can I say one other thing? I have an EDS document.
EDS isn't an official, that's not, right, we don't.
But it says notice of motion, affidavit in support
We
of
don't have
exhibits.
EDS, that's what the court system files. Maybe that's the way you file the papers and you eventually get it. I'm telling you what I have in front of me today. I got a bench trial scheduled for Mr. Taylor.
I'm ready to
And
go.
then I have a bare notice of motion with nothing more.
But EDS says differently. I mean, can I resubmit it?
I'm not, as I said to Mr. Taylor, I've already made a decision on that, I'm not going backward. Again, I'll put it in writing.
Can it be without
You
prejudice
do
or
with
can you
it
file
what
a
you will,
motion?
I'll put it in writing, you do with it what you will.
Can it be without
I
prejudice,
extend
Your Honor?
courtesy to Mr. Taylor. So, right now, I'm listening to him. I'm at the bench trial, he's talking about, I understand he's not comfortable with bench trials. That makes sense for people. So if you're not comfortable with the bench trial, if it's eligible for jury trial, that's another question. But if you want to put in, then do it.
If it's
Tell me
eligible,
what you
if
want.
what's eligible for a jury trial?
What date do you want to do that?
You said if something's eligible?
Right, if it's eligible, if you have to put in, you want to put in a piece of.
If
paper.
what's
You wanna put
eligible?
a jury-
If what's
you wanna
eligible?
put in- If you want to put in, a notice of jury trial on this.
If what's eligible for a jury trial?
I'm not your attorney.
You just said it. I'm asking.
I'm not your attorney, and I'm not here to answer.
And you want me to do a bench trial?
You
gotta be out your mind, man.
You're not ready. Hey,
You're not even answering. I just asked you a question.
let me tell you.
What is eligible?
You're ahead of the game. I dismissed the motion. It's marked for bench trial
You didn't
today.
even answer
You're not
that.
ready. Dismiss the case, you're not ready.
I'm not
I'm
ready.
not gonna do that.
It's not that I'm not ready. I would never do a bench trial.
What's scheduled for that today?
I would never do a bench trial. I just asked you a question and you didn't even answer it.
It's scheduled.
I asked you what was you referring to as eligible or not. You can't even answer that.
It's scheduled for a bench trial today, Mr. Taylor. You know that. You know that. It's scheduled for a bench trial today.
No, it can't be.
And
So we're gonna do a short adjournment, right? So I could put in for a jury demand.
if that's what you want.
Yeah, that's what I want. I said that's what I want. That's my only option here.
Your Honor, I'm gonna be out of the country from the 10th to the 25th of September. I just want to.
So we'll do it other than the 10th to the 25th?
All right, thank you.
So you tell me a date other than the 10th to the 25th, or I pick a date.
Of what, September?
Yeah, other than 10th to 25th of September.
The 10th, and what else?
Other than the date, or I'll just pick a date.
You said, when is he not available? The 10th
10th to the 25th.
to the 25th. So we could do the 26th. That's one day after the 25th.
Yeah, I'm coming back from Australia.
We could do the 27th or the 28th or the 30th.
The following week would be more reasonable. Probably, what are we today? We're on Wednesday? Is it 30th? You want to stick to Wednesdays, October 1st?
Yeah, that's not. Yeah, that's right. That's right there too.
All right.
Can I get a written decision on this, on the Bronx Honda case and the Plaza Honda case? A written decision on both cases, Your Honor, please, before I leave this courtroom. A written
I
decision.
don't have a decision on it. I have a date. So that the
That's still a written. That's still a.
The adjournment's a clerical one. The decision on the motion dismissing it, yeah, I'll send that out. It'd be dismissed the motion. I
It would
don't.
be without prejudice or with prejudice, Your Honor? Well, I guess
I can't stop the people from making motions.
All right.
Okay, so free to do what you want. But, okay.
But whatever goes on in the court with a case, I want documentation of that. It is considered a written. It is considered a decision. Whether it's an adjournment, whatever it is, it's a decision.
It's administrative, for administrative purposes.
Can you please give me a written decision on the Bronx Honda case, please? Can you please give me something in writing, please, of what you did today?
Bronx Honda is already pursuant to Judge DeBerry's order on September 22nd. Judge DeBerry's order, you have that. I saw you show up and pick it up. All right.
So how did you entertain something that has nothing to do with you though? How did you do that? Because that motion has nothing to do with today's court date.
Okay. It's on the calendar, but I noticed that Judge DeBerry signed to the 22nd, so that's why I'm not taking it. Because that's what you said, and I'm, like I was saying before, I'm not going back in time. I'm doing the other judge's decision.
Today's court date for Bronx Honda was scheduled before I filed the order to show cause that Melissa DeBerry signed off on. That court date was scheduled before I filed that order to show cause. So it has nothing to do with what Melissa DeBerry signed off on. It has nothing to do with that. Today's court date is today's court date.
Going by what the other judge did.
Okay,
You appreciate that, right?
I don't appreciate it, because these are two separate court dates.
I'm dealing with decisions of other judges too.
Huh? So can you just give me a written decision? I just want a written decision so I could go. I just want a written decision. If you're not gonna.
DeBerry's decision to return date the 22nd on Bronx. This one, as can be requested. Okay. Anything else, gentlemen?
That's it for me.
Thank you, Mr. Terrell. Thank you, Mr. Honda. Thank you, patience for waiting, and apologies for things I don't know about going in the past. What I want to do is what I can do for myself.
Written decision for Plaza Honda, right?
Right, for that yes, for that motion, yeah, that'll be.
A written decision, period, of what took place today. That's
You give a slip to the date.
no, I said a written decision. That's what I said.
Putting it over.
So you're not giving me a.
That was.
So you're not giving me a written decision for neither one of the cases.
I put that on the record for you.
I want a written decision. I want a written decision.
It's on the record.
So I can still put in for a jury demand, right? For Plaza Honda.
I'm not gonna tell the defendant, make another motion, and I'm not gonna tell you to file a jury demand, so I don't wanna take sides.
So you're not giving me no written decision or
I'm not
nothing.
taking.
Wow, this guy is crazy, man.
If you wanna file a jury demand, you wanna make a motion.
Thank you, Rob.
That's all I've got, thank you.